Good day. My name is B.I.G. Lawal. I'm the principal partner, HARLEM. Today, I want to talk about the legal provisions for authorized interception under the Lawful Interception of Communications Regulations 2019. Having earlier given a detailed background of what lawful interception of private communications is, under what circumstances communications can be lawfully intercepted, and the rest, it is time we also took you through the legal provisions for authorized interception under the Lawful Interception of Communications Regulations 2019. Remember, first off, that Section 70 of the Nigerian Communications Act (NCA) 2003 has conferred on the Nigerian Communications Commission (NCC) the power to make regulations, guidelines, determinations, and the rest. And it is in the exercise of the powers conferred on it, that it published the Lawful Interception of Communications Regulations 2019, which seeks to provide legal and regulatory framework for lawful interception of private communications, collection and disclosure of such intercepted communications in Nigeria, while giving credence to Sections 146 and 147 of the NCA 2003. According to Regulations 4, any authorized agency can intercept any communications where the interception relates to the use of communication service provided by a service provider or licensee to persons in Nigeria or outside Nigeria. According to the regulations, interception can be done with or without a warrant. Under Regulation 7, bordering on interception with a warrant, a service provider shall act upon the warrant issued by a judge authorizing the service provider to comply with the provisions of the warrant to intercept and disclose any communications described in the warrant, and to assist foreign authorities in accordance with an international mutual assistance agreement, as long as there is no other lawful means of investigating the matter for which the warrant is required. Regulations 7 actually, sub 3, goes further to provide that the warrant is necessary to intercept any communications for the purpose of preventing or investigating a crime and safeguarding the economic well-being of Nigeria, or in the interest of public emergency or safety and that of the national security, or for the purpose of giving effect to any international mutual assistance agreements of which Nigeria is a party. Regulation 8 provides for situations where interception is allowed without a warrant, where one of the parties to the communication has consented to the interception, where the interception is done by a party to the communication with sufficient reason to believe that there is a threat to human life and safety, and also where in the ordinary course of business it is required to record or monitor such communication. Now, how do you apply for a warrant? In the case of a warrant being necessary pursuant to any international mutual assistance agreement of which Nigeria is a party, such application for a warrant is made through the Attorney General of the Federation, and the applicant must show evidence of authority from the relevant country. All applications for a warrant shall be in writing and contain full details of circumstances alleged by the authorized agency in support of the application for that warrant. It must also be supported by an affidavit on oath, clearly indicating that interception of such communication is the only means by which the relevant information necessitating the warrant could be obtained. Regulations 12 sub 4 goes further to say that any authorized agency may cause interception without a warrant where immediate danger of death or serious injury to any person is likely to be occasioned, or where there are activities that threaten the national security, or even where such activities are characterized as an organized crime. In all these cases, however, the authorized agency must, within 48 hours after the commencement of interception, and where the application is not made or where it is denied within the stipulated 48 hours, the interception must terminate immediately, and further interception after this moment shall be deemed illegal and unlawful. Regulation 13, sub 12, Regulation 13 sub 2 rather, makes copious provisions as to what the warrant authorizes the authorized agency to do, part of which is to take possession of and examine any communication, listen to, or make recording of any communications to which the warrant relates. The authorized agency is also allowed to enter into any premises, board, vehicle, vessel, or aircraft for the purpose of enforcing the warrant, or to install or remove a monitoring device, or to intercept or take possession of any communication, or to install, maintain, or remove a device by means of which any communication can be intercepted for the purpose of the regulations, provided, of course, that the monitoring device shall be the brand approved by the NCC and shall not negatively affect the provisions of communication service by the service provider or licensee. Adjunct to Regulation 13 is a proviso that where a judge refuses an application for a warrant for interception that has already begun, any information obtained before the refusal shall neither be valid nor admissible for the purpose of prosecution of any person affected by it. Now, let's quickly talk about the duration, cancellation, amendment, and renewal of a warrant as provided for under Regulation 14. A warrant is granted for an initial period of 3 months or any other lesser period that the judge determines, and shall cease to have effect at the expiration of the period stipulated in it, unless it is renewed by the judge at any time before the expiration of the period for which it was issued, upon an application brought by any of the authorized agencies for renewal for a maximum period of 3 months or such lesser period as the judge may determine. The warrant may also be amended by a judge at any stage during the validity of such warrant, but an application for such amendment must be made to the judge by the authorized agency and must contain reasons for the amendment. An application for cancellation of the warrant can also be made to the judge by any of the authorized agencies with a notice to the service provider that the warrant earlier granted is no longer necessary on grounds falling under Regulation 7 sub 3 earlier discussed, and the service provider shall then notify the NCC of such cancellation within 48 hours of the receipt of notice of cancellation from the authorized agencies. Regulation 15 states that for the purpose of the execution, all warrants issued under the regulation shall be executed by State Security Services (SSS), Office of the National Security, as well as the Nigerian Police. Where any person, service provider, or his officers violate the provisions of the regulation, such person or service provider shall then be liable to a fine of 5 million naira, and where the offence persists, a sum of 500,000 naira daily default penalty shall also be paid. Also, the NCC may revoke the license of a service provider in line with Section 45 of the NCA for failure to comply with the provisions of the regulations. The NCC may also institute an action for non-compliance by way of specific performance or an injunction or any other of the court as a means of enforcing compliance with these regulations. For any questions on this lecture, please feel free to send in your mail to biglaw@harlemsolicitors.com. Thank you for listening and best wishes from Harlem. Bye-bye.